Acquisition and loss of territory, international law. Introduction. In international law, territory is a fundamental element of statehood. A state exercises sovereignty on its defined territory. Territory is an essential element of statehood under international law. A state cannot exist without a defined territory. The rules relating to acquisition and loss of territory have developed through customary international law, judicial decisions, treaties, and the UN Charter. Traditionally, several modes of acquisition were recognized, but modern international law, especially after 1945, has restricted some methods such as annexation by force. Modes of acquisition of territory. There are different modes by which a state can acquire territory. These are as follows. Occupation. Occupation is a mode of acquisition of territory under international law by which a state acquires sovereignty over terra nullius, land belonging to no state. Occupation means acquisition of a territory which is not under the sovereignty of any state, by establishing effective and peaceful control over it. It requires both intention and effective control. Essential conditions of valid occupation. Terra nullius. The territory must be terra nullius. Terra nullius is a Latin term meaning land belonging to no one. Land inhabited by organized tribes is not terra nullius. Intention to acquire. Animus occupandi. The state must intend to exercise sovereignty. Effective control. Corpus possessionis. There must be actual administration or display of authority. Peaceful possession. It should not violate international law. Case. Island of Palmas case, 1928, Island of Palmas. Decided by the Permanent Court of Arbitration. The United States claimed the island based on discovery, but the Netherlands proved continuous and peaceful display of authority. Principle. Effective and continuous control is more important than mere discovery. Prescription. Prescription is a mode of acquisition of territory by which a state acquires sovereignty over territory through long, peaceful, continuous and uninterrupted possession, without objection from the original sovereign state. Prescription means acquisition of territorial sovereignty by the continuous and peaceful exercise of authority over a territory belonging to another state, with the knowledge and acquiescence of that state. It is similar to the concept of adverse possession in municipal law. Essential conditions of prescription. Continuous possession. Control must be exercised for a long period. Peaceful possession. No use of force. Public possession. Acts must be open and visible. Acquiescence. The original state must not protest, acquiesce. If the original state continuously objects, prescription cannot operate. Prescription is similar to the concept of adverse possession in municipal law. Accretion. Accretion is acquisition of territory through natural causes. Accretion is a mode of acquisition of territory whereby a state gains new land through natural processes, without any human intervention. It occurs automatically when land is added to existing territory due to natural causes. Accretion means the gradual and natural increase of territory by operation of nature. Causes of accretion. Alluvion, gradual deposit of soil by rivers. Formation of new islands. Avulsion, sudden change in river course, though legal consequences differ. Formation of new islands due to volcanic activity. Recession of sea waters exposing new land. If a river forms a boundary between two states and the change is gradual, alluvion, the boundary shifts accordingly. If the change is sudden, avulsion, the boundary usually remains the same. Cession. Cession means transfer of territory by agreement or treaty. Cession is a mode of acquisition, and loss, of territory by which one state transfers sovereignty over a part of its territory to another state through a treaty or agreement. It is a peaceful and lawful method of transferring territory. Cession means the transfer of territorial sovereignty from one state to another by mutual agreement, usually through a treaty. Essential features. Agreement or treaty is necessary. Consent of both states must be present. Transfer of sovereignty takes place. It may be permanent or subject to conditions. Types. 1. Voluntary cession. transfer of territory by mutual agreement without coercion. 2. Cession after war, territory transferred as part of a peace treaty after war. Modern international law discourages territorial transfer through force. 3. Cession by sale, territory transferred in exchange for money or compensation. Legal position: cession is a valid mode of acquisition under international law. It must not violate the principles of the United Nations Charter. Use of force is prohibited under Article 2(4). Consent must be genuine and free. Annexation. Annexation is the forcible acquisition of territory by one state from another through use of force or conquest. Annexation is the acquisition of territory by a state through use of force or conquest, followed by formal declaration of sovereignty over that territory. Traditionally, annexation was recognized, but under modern international law it is illegal. Annexation means the forcible acquisition of territory of one state by another state and its incorporation into the acquiring state. Modern legal position: after the UN Charter, 1945, acquisition of territory by force is illegal. Article 2(4) of the UN Charter prohibits the use of force against the territorial integrity or political independence of any state. Acquisition of territory by force is not recognized as lawful. International law now protects territorial integrity. Therefore, annexation is illegal under modern international law. Lease. A state may lease part of its territory to another state for a specific period. Sovereignty usually remains with the original state. Lease is a mode under which one state grants another state the right to use and administer a part of its territory for a specified period, while sovereignty remains with the original state. Lease means a contractual arrangement by which one state allows another state to exercise certain rights over a portion of its territory for a fixed period under agreed conditions. Essential features: agreement or treaty between states. It is temporary in nature. The sovereignty remains with the lessor state. Lessee state exercises limited control as per agreement. It is a temporary transfer of possession, not ownership. Example: Guantanamo Bay Lease Agreement, 1903, Guantanamo Bay. Between United States and Cuba, the United States obtained control over Guantanamo Bay, but Cuba retained ultimate sovereignty. Thus, lease is a temporary arrangement under which one state grants another state the right to use and administer part of its territory while sovereignty remains with the original state. Plebiscite. Plebiscite means acquisition of territory based on will of the people. Plebiscite is a method of determining the sovereignty of a territory by taking a direct vote of the people living in that territory. Plebiscite means a vote by the inhabitants of a disputed territory to decide which state they wish to belong to. Essential features: free and fair voting process. People vote to decide sovereignty. Supervision by international authority, sometimes. Based on consent of the people. Based on principle of self-determination. Reflects the principle of self-determination. Legal basis: principle of self-determination recognized under the United Nations Charter. Used in resolving territorial disputes after wars or decolonization. Examples: 1. Saar plebiscite, 1935 people of Saar voted to join Germany. 2. Junagadh plebiscite, 1948 people voted to join India. Thus, plebiscite is a method of determining territorial sovereignty by taking a direct vote of the people of the disputed territory. It is based on the principle of self-determination and is recognized under the UN Charter. It is a peaceful and democratic method of resolving territorial disputes.